The rain had been threatening all morning, low clouds pressing down over the city of Harwell like a ceiling that could not decide whether to hold or collapse. The streets of the Meridian district were slick, catching the pale October light and throwing it back in fragments. It was 8:47 in the morning on a Tuesday, and the intersection of Carver Boulevard and 5th Street was as ordinary as any other. A dry cleaner, a coffee shop with fogged windows, a parking attendant booth with a cracked plastic roof, and 3 parallel parked cars along the east curb, one of which was a black BMW 5 Series with a Bar Association sticker on the rear windshield and a briefcase visible through the glass on the back seat. Marcus Webb had been standing outside that car for less than 4 minutes. He had come from the coffee shop. He was holding a tall paper cup in his left hand and had his key fob in his right. He was wearing a charcoal gray suit, a white dress shirt with the top button closed under a Windsor knotted tie the color of burgundy, and shoes that caught the dull morning light the way good leather does when it has been carefully polished. He was 38 years old. He was 6 feet tall. He was black. And in the mind of the man now pulling his squad car to the curb behind the BMW, those facts formed the complete and sufficient basis for everything that would happen next. Officer Brian Colton had been on the Harwell Police Department for 11 years. He was broad across the shoulders, with a jaw like a cinder block and pale blue eyes that moved through a crowd the way a camera does, scanning, categorizing, settling. He had a service record that was longer than his commendations, and a disciplinary file that sat in the Internal Affairs Cabinet like a loaded weapon no one wanted to pick up. He had been investigated 4 times. He had faced review twice. He had been formally reprimanded once for what the department log described as a disproportionate use of force during a routine traffic stop, a phrasing so euphemistic and so carefully worded that the actual image of a man bleeding on a curb in the South Side neighborhood was rendered invisible by bureaucratic language. He had never been suspended. He had never been charged. He had, in the parlance of a police union that protected its own the way a reef protects the bacteria living inside it, been given every benefit of every doubt that existed, and several that had to be invented. He got out of the squad car on a Tuesday morning in October and walked toward Marcus Webb with the particular gait of a man who had already decided the outcome of the conversation. "Hey," Colton said. "Not sir. Not excuse me. Not good morning. Just hey. The way you speak to something you have not yet decided is a person." Marcus turned. He had heard that tone before. He had heard it the first time when he was 16, standing outside a convenience store in the neighborhood where he grew up, waiting for his mother who was inside buying milk. He had heard it many times since then, and each time he had made a calculation, silent, fast, efficient, about what posture and what words would cost him the least. He made that calculation now, and his face settled into what people who knew him called his courthouse face. Measured, neutral, present. "Morning," Marcus said. Colton stopped about 4 feet away. His thumbs were hooked into his belt, near the buckle. His eyes moved over Marcus the way a customs officer's hands move through luggage, looking, not for what was declared, but for what was concealed. "This your vehicle?" Colton asked. "It is," Marcus said. "You got ID?" Marcus held the coffee cup steady. His voice did not change. "Can I ask what this is about?" "I asked you a question," Colton said. "Do you have ID?" "I do," Marcus said. "But you haven't told me why you're asking." "I'm standing next to my own car. I have not committed any traffic infraction. I'm not in a restricted area. What is the basis for this stop?" The words were precise. Not aggressive. Not pleading. Precise. The words of a man who understood exactly what a Terry stop required, exactly what the Fourth Amendment protected, and exactly what a citizen in a public space was and was not required to do. But Colton did not hear the words as precise. He heard them as resistance. And in Brian Colton's lexicon, resistance from a black man standing on a city street meant one and only one thing: escalation. "Step away from the vehicle," Colton said. "I'm not doing anything wrong," Marcus said, his voice still even. "I said step away from the vehicle." The volume rose. Not shout. Not yet. But the edge was there, the serrated border between authority and threat. "Right now? Move." Marcus held the coffee cup. He took one breath. He said, "I would like to know why I'm being detained." What happened next took 3 seconds. Colton moved forward. He grabbed Marcus by the left shoulder of his suit jacket, the hand that had never been extended in courtesy now closing around fabric and flesh, and he turned him and drove him forward against the driver's side door of the BMW with a force that was not incidental and was not accidental. The impact was full-bodied. Marcus's face struck the roof line of the car, not the glass, not enough to shatter anything, but enough to split the skin above his left eyebrow and drive his cheek into cold metal. His coffee cup hit the sidewalk and burst. The key fob clattered into the gutter. His arms were pulled behind his back with the practiced efficiency of a man who had done this before, had done it many times, had never once been made to answer for it. He felt the cuffs click shut. "Don't move," Colton said, breathing slightly harder now. "You don't comply, this is what happens. You understand me? You don't comply." Marcus said nothing for a moment. His cheek was against the cold metal of the car roof. He could feel the wet heat of blood above his eyebrow, where the skin had split. He could hear traffic. He could hear the distant sound of the coffee shop door opening as someone stepped out, stopped, stood. He could hear his own heartbeat with a clarity that only certain kinds of fear produce. Not the fear of dying, but the fear of being unmade in public, of being reduced in full view of strangers to something that has no voice and no rights and no name. Then he said, quietly, steadily, "My name is Marcus Webb. I am an attorney licensed to practice in this state. My bar identification is in my inside jacket pocket. My vehicle registration is in the glove compartment. And everything that is happening right now is being documented." Colton said nothing, but something shifted in the air. A woman had stepped out of the dry cleaner 2 storefronts down. She had her phone raised. On the other side of the street, a man in a construction vest had stopped walking and was also filming. The parking attendant in the cracked roof booth had straightened in his chair. The person who had come out of the coffee shop, a young woman in a law school hoodie, second year at Harwell University School of Law, who had been behind Marcus in line and had recognized him from a guest lecture 2 weeks before, was already dialing, not 911, but a number she had memorized because she had clerked for a civil rights organization the previous summer and had been told, specifically, unambiguously, to keep that number ready. She was calling the Harwell Civil Liberties Legal Defense Fund. She was calling the direct line of a woman named Diana Cross. Colton, unaware of all of this, leaned close to Marcus's ear and said, "I don't care what you say your name is." It was the most revealing sentence he had ever spoken in his life, and he did not know it yet. A second squad car arrived 4 minutes later. The officer who got out was younger, a man named Torres who had been on the force for 2 years and who hesitated, visibly, when he saw what was happening. A man in a business suit, hands cuffed behind his back, blood on his face, standing against a luxury vehicle in a well-lit public intersection at 9 o'clock in the morning. Torres's hesitation lasted about 4 seconds before the training and the culture and the weight of the institution above him pressed it back down. He walked over. He said nothing about what he was seeing. He asked Colton if everything was under control. "Run the plates," Colton said. Torres ran the plates. The vehicle was registered to Marcus Elijah Webb. Address listed was a residence in the Northgate neighborhood, one of the more affluent areas of Harwell. Torres read the address out quietly. Colton did not react. "Run his name," Colton said. Torres typed. He waited. He read what came back. His expression changed in a way he could not prevent. A small but visible contraction of the features, the face doing what faces do when the information arriving is irreconcilable with what the body has already committed to. He turned to Colton. He said, quietly, "He's clean. No priors. No warrants. Nothing." Colton said. He was being uncooperative. Torres said nothing. Colton said, "Call it in as a public disturbance, possible DUI." Torres said, and this was the second pivotal thing said in this intersection on this morning, "Brian. He's not drunk. He's in a suit. Brian, there are people filming." Colton looked around for the first time. He saw the woman with the phone. He saw the man in the construction vest. He saw the law student on the coffee shop steps. His jaw tightened, but his hands, already committed, did not unclench. The cuffs stayed on. The blood continued its slow line down the side of Marcus Webb's face. And Brian Colton, 11-year veteran of the Harwell Police Department, stood on Carver Boulevard in the morning rain light and did not move, because the one thing his experience had taught him, the one lesson that 11 years inside a protected institution had thoroughly calcified into reflex, was that movement meant concession, and concession meant weakness, and weakness, in the world he inhabited, was the only thing that actually cost you something. He was wrong about that, but he would not know how wrong for another 14 months. Marcus was transported to the Meridian precinct in Torres's vehicle. He was put in a holding area, not a cell, a holding area, which was a distinction the intake officer noted with some care, as though the geography of the room would insulate what had happened from what it was. His personal items were logged: a wallet containing 3 credit cards, a driver's license, a bar association card, and a folded photograph, a phone, model and serial number noted, a briefcase key, a watch, silver-faced, that had been given to him by his father on the morning he passed the bar exam. His wrists bore the shallow red lines that handcuffs leave when applied with more force than necessary. The cut above his eyebrow was examined by a duty officer who pressed a paper towel to it, decided it was not deep enough to require medical intervention, and wrote in the log minor laceration, no treatment required. Marcus asked 3 times to make a phone call. He was told 3 times that he would be able to do that shortly. Shortly meant 47 minutes. When the phone was finally brought to him, he made 1 call. Not to a family member, not to a friend. He called his office. The woman who answered was his legal assistant, a woman named Priya who had worked with him for 6 years and who knew, from the specific quality of stillness in his voice, that something had happened that was going to require her to clear his entire day. "I'm at the Meridian precinct," he said. "I need you to contact Gerald Ash and tell him the deposition this afternoon will need to be rescheduled. Tell him I'll explain when I can. And I need you to contact Diana Cross at the HLDF." Priya said, "Are you hurt?" He said, "Get Diana Cross." He was released without charge at 11:32 in the morning. No charges were filed. No incident report that adequately described what had happened on Carver Boulevard was submitted. The report that was submitted described the encounter as a field interview following suspicious behavior by an individual near a parked vehicle. The individual became verbally confrontational, was detained for public safety purposes, was cooperative upon transport, and was released after standard processing. It was a document of absolute fiction assembled from the vocabulary of institutional self-protection, and it bore the signature of Officer Brian Colton and the counter-signature of the Meridian Precinct Duty Supervisor, a man named Lieutenant Gerald Farrow who had been a supervisor for 9 years and who had co-signed enough of these reports over those 9 years to have lost the ability to read them as anything other than paperwork. Marcus stood on the precinct steps with his briefcase, which had been retrieved from his vehicle and brought in, a gesture that struck him as darkly ironic, that they had taken care of his property while taking him, and he buttoned the top button of his jacket, which was all he could do about the fact that his tie was slightly off-center and his left cuff was stained with a faint arc of dried blood. He stood there for a moment in the late morning cold, looking at nothing in particular, his face composed and his eyes absolutely still. Then he walked to the corner, flagged a taxi, and went to his office. His office was on the 14th floor of the Drummond Building in downtown Harwell. The firm's name, Webb & Associates, was etched in the frosted glass of the reception area in understated block letters that conveyed exactly what Marcus intended them to convey: weight without ostentation, authority without announcement. He had built the firm from a 2-room suite with a single paralegal 8 years ago. He now employed 12 attorneys, 4 of whom were former public defenders, 2 of whom had clerked for federal judges, and 1 of whom, his partner, a woman named Allison Trask, had argued twice before the state Supreme Court and won both times. He walked past the front desk without stopping and went to his office. Priya followed him in and closed the door. She saw the cut above his eyebrow, which had sealed itself but left a faint crust of dried blood at the hairline. She saw the stain on his cuff. She set a glass of water on his desk. Diana Cross called back. Priya said, "She's coming in at 1. "Good," Marcus said. "Do you want to tell me what happened?" He sat down. He looked at the window. He said, "I was standing next to my car holding a cup of coffee, and a police officer decided that was enough." Priya said nothing for a moment. Then she said, "I'm sorry, Marcus." He said, "I know." Diana Cross arrived at 12:53. She was 51 years old, compact and formidable, with short natural hair going silver at the temples, and the particular kind of composure that comes not from having been untouched by things, but from having been touched by them so often that the skin has hardened into something almost geological. She had been a civil rights litigator for 23 years. She had won settlements from 3 municipalities and 2 police departments. She had argued before 2 federal circuit courts and lost one, won one, and appealed the loss to a court that ultimately ruled in her favor 2 years later. She did not panic in depositions. She did not raise her voice in courtrooms. She had been told, by a judge who meant it as an insult, that she argued like a machine, and she had taken that as the highest possible compliment. She came in, sat down, looked at Marcus's face, and said, "Tell me everything." He told her everything. He spoke without editorializing, without dramatics, in the same clear, sequential voice he used when presenting facts to a jury. Time, location, what he was doing, what was said, what happened, what was not said, what was done after. Diana Cross took notes. She did not interrupt. When he finished, she looked at her notes for a moment, then looked at him. "The law student," she said. "The one who was filming. Her name is Kezia Okafor," Marcus said. "Second year at Harwell. She sent me the footage this morning before I came in. She caught the whole thing from the moment Colton got out of his car. 51 seconds of clear, unobstructed video." Diana Cross looked at him. "Show me," she said. He turned his laptop around. The video was 49 seconds, not 51, but the difference was irrelevant. What the video showed was everything. It showed Officer Brian Colton approaching a man in a business suit who was standing calmly on a public sidewalk next to a car. It showed a brief exchange of words. It showed Colton reach out and grab the man by the shoulder and drive him into the vehicle with the full weight of his body. It showed the man's face hit the car. It showed the cuffs. It showed blood. It showed Colton leaning in close to say something that the audio did not capture, but the body language described in unmistakable terms. Not the posture of law enforcement, but the posture of dominance, of someone pressing a boot against something that was already down. Diana Cross watched it once. Then she watched it again. Her face did not change. Her pen had stopped moving. She said, "Who else has this footage?" "Kezia," Marcus said. "The woman from the dry cleaner sent a copy to a local news outlet this morning, apparently. I don't know which one. The man in the construction vest, his name is Dario Munez. I found him through the parking attendant who was on duty. He hasn't shared it publicly yet, but he's willing to provide a copy and a witness statement." Diana Cross set her pen down. She said, "I need to ask you something, and I need you to answer me honestly, not as a lawyer, just as a person." "Go ahead," Marcus said. "How are you doing?" The question was simple. Simple questions, Marcus had learned, were sometimes the heaviest ones. He looked at the window again. Outside, 14 stories down, the city moved with its ordinary indifference. Cars turning corners, pedestrians crossing, a delivery truck idling against a yellow curb. He thought about what it meant to have moved through that city for 38 years carrying something invisible and immovable, something that no degree or bar card or tailored suit could redistribute, and to have stood on a public sidewalk on a Tuesday morning holding a cup of coffee, and to have had a man in a uniform decide, in a glance, in a judgment that happened faster than thought, that none of that mattered. "I'm functioning," he said. "That's not what I asked," Diana said. He looked at her. "I'm angry," he said. "I have been angry for a very long time. Today I know his name." She nodded. She picked up her pen. "Then let's build a case around it." The complaint was filed with the Harwell City Attorney's Office on November 4th, 21 days after the incident on Carver Boulevard. It was a 47-page document that included a federal civil rights claim under 42 U.S.C. Section 1983, a state battery claim, a claim for false arrest, and a claim for racial profiling in violation of the Harwell Municipal Equal Protection Ordinance, which had been passed 3 years earlier after a public campaign that Marcus Webb had himself quietly helped finance. The complaint named Officer Brian Colton in his individual capacity, the Meridian Precinct Supervisor Lieutenant Gerald Farrow in his supervisory capacity, and the city of Harwell as the entity responsible for the policies and customs that had made this possible. The complaint was 47 pages long. The exhibit package that accompanied it was 219 pages. It included Kezia Okafor's video, enhanced and timestamped. It included Dario Munez's video, which had captured a slightly different angle and showed, with particular clarity, the moment when Marcus's forehead made contact with the car. It included photographs of the laceration and the bruising, taken at an urgent care facility Marcus had visited the afternoon of the incident, where a physician documented a 1.4 centimeter laceration above the left orbital ridge consistent with contact with a hard blunt surface and contusions on both wrists consistent with tight application of metal restraints. It included the incident report filed by Colton, and next to it, a side-by-side narrative comparison demonstrating, sentence by sentence, the specific ways in which that report contradicted the video record. It included Officer Torres's patrol log, which documented the time of arrival at the scene and the plate check, in which a careful reader would note did not use the phrase DUI and did not use the phrase suspicious behavior, the two phrases that appeared in Colton's report. It included Brian Colton's full disciplinary file, which Diana Cross had obtained through a public records request that had taken 16 days and one formal follow-up demand to fulfill. The file contained 4 investigated complaints. 3 were from black men. 2 of those had occurred within a 2-mile radius of Carver Boulevard. One of those 2, a complaint filed by a man named Robert Tanner 4 years ago, described an encounter with a near-identical structure, approached without cause, asked to produce ID without basis, handcuffed when he questioned the request, transported, released without charge. Tanner's complaint had been reviewed and closed with a finding of no policy violation. The officer who reviewed it was Lieutenant Gerald Farrow. The document was, by any technical legal standard, a thoroughgoing construction. It was also, by any human standard, a portrait of something that had been allowed to exist and grow inside an institution that had chosen, repeatedly, when given the chance to address it, to look away. The city attorney's office acknowledged receipt of the complaint in a letter that was 16 lines long and said, in effect, nothing. A response period of 30 days was standard. The 30 days passed. A 45-day extension was requested. Diana Cross did not grant it. She filed for a preliminary injunction demanding the immediate suspension of Officer Colton pending the outcome of the investigation and submitted the filing to the Harwell County District Court at 9:15 in the morning on a Friday. By 3 o'clock that same afternoon, the Harwell Courier had run a story on their website. The headline read, "Local attorney files federal civil rights suit against city, claims police officer slammed him against car without cause." The story included a still image from Kezia Okafor's video, the moment of impact, frozen, that made the abstract concrete in the way that only images can, reducing an institution's paper language to a single frame of a man in a suit with his face against a car door and a uniformed officer's hand on his back. The story was shared 4,200 times in the first 6 hours. By the following Monday, it had been picked up by 3 regional television outlets, 1 national wire service, and a civil rights advocacy organization with 2.1 million social media followers who posted the video in its entirety with a single caption that read simply, "His name is Marcus Webb. He is a lawyer. He was going to work." The city's public relations office issued a statement expressing a commitment to thorough review of all complaints filed against department personnel and affirming the department's dedication to fair and equitable policing in all communities. It was the kind of statement that had been written so many times by so many public relations offices in so many cities that it had been stripped of every gram of meaning, a skeleton of language dressed in the clothes of accountability. The Harwell Police Officers Association issued its own statement, expressing support for Officer Colton and describing the incident as a lawful investigative detention conducted in good faith, and noting that prejudging officers based on incomplete information was harmful to public safety. The statement was attributed to Union President Gary Mullen, who had spoken at Colton's wedding 6 years ago and whose photograph with Colton at a department fundraiser was, as of that Monday afternoon, still publicly visible on a social media platform that neither man had thought to review. Brian Colton had not been suspended. He had been placed on administrative assignment, meaning he reported to a desk in a back room of the Meridian precinct and processed paperwork and did not go out on patrol. This was presented publicly as a demonstration of good faith accountability and was understood by everyone involved, by the union, by the city, by Lieutenant Farrow, by Diana Cross, and most certainly by Marcus Webb, as what it actually was, a minimal concession designed to reduce the public temperature without conceding anything of legal substance. It did not reduce the temperature. Marcus Webb had not spoken publicly in the 2 weeks since the story broke. He had declined 3 interview requests from television stations, one from a national newspaper, and one from a documentary filmmaker who had contacted the office directly. He had continued working. He had attended court twice, arguing on behalf of a client in a wrongful termination case in federal court, and had performed, by every observable metric, as though nothing in his personal life had been disturbed. People who saw him in those courtrooms noticed that he was quieter than usual, more deliberate, the way a river is more deliberate when it narrows. Not less powerful, but more focused, the energy concentrated by the constraint of the banks. He gave his first interview 22 days after the story broke, to a journalist named Claudette Baines at the Harwell Public Record, a mid-size investigative publication with a serious reputation and a readership that skewed professional and civic. He chose Baines specifically because her previous work included a 3-part investigation into the HPD's use of force data that had been the foundation for the municipal ordinance he had helped pass. He trusted her not to be sensational. He trusted her to be thorough. The interview was published under the headline, "He Knew His Rights." It didn't matter. He said, in the portion of the interview that was most widely quoted afterward, "I have stood in front of judges and argued constitutional law. I have briefed state and federal courts on the Fourth Amendment. I knew every procedural right I had while I was standing on that sidewalk. And I want you to understand something clearly. Knowing your rights is not a shield. It is, in some situations, a provocation. Because what certain people in positions of authority cannot tolerate is not ignorance. It is competence. It is a black man who knows the law better than they do. And that is what I represented on that sidewalk. Not a threat. Not a crime. Knowledge. And for that, I bled." The piece ran on a Thursday morning. By Thursday evening, it had reached a national audience. By Friday morning, 3 members of the Harwell City Council had issued statements calling for an independent investigation. By Friday afternoon, the mayor's office had announced that the Department of Justice's Civil Rights Division had made a preliminary inquiry about the city's policing practices in response to a series of community complaints, the present case being the most recent and most publicly documented. The preliminary inquiry was, in the language of federal oversight processes, the lightest possible touch. It did not yet constitute an investigation. It did not carry subpoena power. It was a letter of inquiry and a request for documentation, something bureaucratic offices sent as a first gesture, an antenna extended to see what signal came back. But it was also, in a way that any experienced civil rights attorney would recognize, the first crack in the foundation. Diana Cross recognized it immediately. She had been in this situation before. Not this exact situation, but the structural equivalent. The moment when a case that had been absorbed into an institution's self-protective immune system began instead to attract outside attention, outside scrutiny, outside forces that the institution could not control or negotiate with or quietly suppress. She had watched cases die in this stage before, watched institutions absorb the pressure and exhaust the momentum and wait out the news cycle until the next event replaced this one in the public's attention. She had also watched cases survive this stage, had watched them draw reinforcements, had watched them build sufficient structural weight that no institutional inertia could absorb them. Whether this case survived would depend on what happened at the deposition of Officer Brian Colton, which was scheduled for the second week of January. Colton arrived at the deposition with 2 lawyers, one from the police union and one from the city's legal defense firm, a corporate-adjacent practice called Bancroft, Himes & Weil, whose representation of municipal clients had generated $17 million in billable hours over the previous decade. The union lawyer was named Peterson, a man in his late 40s with careful hair and a manner of aggressive, relaxed confidence designed to communicate that he had been through many of these and found them, at worst, mildly inconvenient. The city's lawyer was a younger woman named Carver, whose precision indicated she had read every document in the case file at least twice and intended to litigate every possible procedural inch. Colton himself came in wearing civilian clothes, pressed dark pants, a button-down shirt without a tie, and took his seat across the conference room table from Diana Cross with the practiced neutrality of a man who had been coached extensively. His face was settled. His hands, folded on the table, were still. He had been told, clearly and at length, to answer only what was asked, to volunteer nothing, to say "I don't recall" when memory was ambiguous, and to treat the opposing counsel the way a stone wall treats weather. Diana Cross looked at him for 3 seconds before she spoke. It was a deliberate pause, the kind that costs nothing but communicates everything, that she was not hurried, that the pace of this room was hers to set, and that she had time. She said, "Officer Colton, can you describe for me what you observed on the morning of October 6th that caused you to stop your vehicle and approach Mr. Webb?" Colton said, "I observed an individual in the area of a parked vehicle who appeared to be engaged in suspicious behavior." "What specific behavior?" Diana said. "Did you observe that you characterized as suspicious?" "He was standing near the vehicle in a manner that appeared inconsistent with normal parking activity." "What does normal parking activity look like to you?" Peterson said, "Objection, calls for speculation." Diana said, "This is a deposition, not a trial. I'll note the objection and continue." "What does normal parking activity look like to you, Officer Colton?" Colton said, "Someone who is returning to a vehicle typically approaches it, unlocks it, and gets in." "And what was Mr. Webb doing that deviated from that pattern?" "He was standing beside the vehicle holding a beverage." Diana Cross paused. She let the sentence sit in the air of the conference room, let it settle against the depositions of the parking attendant and Dario Munez and Kezia Okafor, who had each stated that Marcus Webb had just exited the coffee shop and had the key fob in his hand, and let it settle especially against Colton's own incident report, which described suspicious behavior without defining what that behavior was. "He was holding a coffee cup," Diana said. "Correct. Outside a coffee shop. He was near a parked vehicle. He was standing next to his own registered vehicle, having just purchased a beverage from a business establishment approximately 30 feet away at 8:47 in the morning on a weekday. Is that accurate?" "I observed what I observed." Diana Cross let another pause land. Then she opened a folder and placed a photograph on the table. It was a still from Kezia Okafor's video, timestamped, showing Marcus Webb standing next to the BMW with the coffee cup visible in his left hand and the key fob clearly visible in his right. "Officer Colton," she said, "in this image, which was taken 4 seconds before you exited your vehicle, can you point to the specific behavior that you characterized in your report as suspicious?" The union lawyer said, "Objection to the framing." Diana said, "I'll rephrase. In your professional judgment as an 11-year veteran of the Harwell Police Department, looking at this image, what do you see that warranted a field stop?" Colton looked at the photograph. He said, "The totality of the circumstances." "What circumstances?" Diana said, "Tell me one." The room was quiet. Peterson leaned slightly toward Colton. Colton said, "The area had a history of vehicle break-ins." "Does it?" Diana opened another folder. "The crime statistics log for Carver Boulevard and the surrounding 2-block area in the 12 months preceding October 6 show 4 reported vehicle-related incidents. 2 of those were vandalism. 1 was a parking dispute. 1 was a hit-and-run. None were break-ins within 6 blocks of that intersection in the 12 months before October 6. Where did you get the information that this area had a history of vehicle break-ins?" "That is general knowledge within the precinct about patrol areas." "Can you produce a memo, a briefing, a shift log, any documented communication of any kind that describes the Carver Boulevard area as a high-risk zone for vehicle theft?" Peterson said, "The officer will not be producing internal documentation in this setting." Diana Cross looked at Peterson the way a surgeon looks at an incision they were expecting to make. She said, "I will be subpoenaing those documents through the court. I am noting your refusal to produce them voluntarily for the record." She turned back to Colton. "When you approached Mr. Webb and he asked you for the legal basis of the stop, how did you respond?" "I asked him to identify himself." "And when he asked you to explain the basis for the request?" "I instructed him to step away from the vehicle." "Why?" "For officer safety." "What safety threat was present?" "Any individual who declines to cooperate with a lawful instruction presents a potential safety concern." "He asked you a legal question," Diana said. "He asked you on what basis you were conducting a stop. Is asking a legal question a safety threat?" Peterson said, "Counsel is mischaracterizing the witness's testimony." Diana said, "I'm quoting the witness's testimony. I'll play back the transcript if that would help." She set a third document on the table. "Officer Colton, in the 47-second video taken by Ms. Okafor, from the moment you exited your vehicle to the moment you drove Mr. Webb into the car, 47 seconds. Mr. Webb raised his voice at no point. He made no physical movement toward you. He did not reach into his jacket or his pockets. He made no threatening gesture of any kind. Is that accurate? Colton said. I perceived a threat. Based on what? The silence this time was different. It was not the silence of a careful witness managing his answers. It was the silence of a man arriving, perhaps for the first time in this particular way, at the full perimeter of his own justification and finding it smaller than he had believed. He said, my training and my experience. Diana Cross looked at him. She said, your experience. Let's talk about your experience. She opened a fourth document, the disciplinary file. In November of 2019, a complaint was filed against you by a man named Robert Tanner, alleging that you approached him without cause, requested identification without basis, handcuffed him when he questioned the request, and transported him without charge. Does that sound familiar? Peterson objected. Diana noted it and continued. Colton said, I recall the complaint. And in March of 2021, a complaint was filed by a man named Jerome Ellis alleging nearly identical conduct. In September of 2022, a complaint was filed by a man named Calvin Wright. Do you recall those? I recall that complaints were filed. All three of those complainants were black men. All three were approached in public spaces. All three were handcuffed when they questioned the basis of the stop. None of the three were charged with any offense. Is that accurate? I can't speak to other cases. You can speak to your conduct in them, Diana said. And you will. Because those three men have now been located and retained as additional witnesses in this matter. She let that settle. She let it land with the full weight of its implications, that this was no longer a single incident, that it was a pattern, that the single case on Carver Boulevard had become the visible surface of something beneath, something that had been recorded and documented and suppressed, and was now being excavated. Colton's composure held, but it held the way ice holds on a river in late March, maintained, but only by not pressing on it. The deposition lasted 4 hours and 23 minutes. At its conclusion, Diana Cross thanked the court reporter, gathered her materials, and stood. She looked at Colton one final time and said nothing. She did not need to. Discovery lasted 6 months. In those 6 months, the following occurred. The Department of Justice's preliminary inquiry was upgraded to a formal civil rights pattern or practice investigation covering the entire Harwell Police Department, based on data analysis that showed black residents of Harwell were subjected to field stops at 3.4 times the rate of white residents despite comparable neighborhood crime rates, and that those stops resulted in use of force at 2.8 times the rate. The investigation was broad. It subpoenaed 5 years of departmental records, body camera footage where available, incident reports, disciplinary files, and internal communications. It was the kind of investigation that institutions do not survive intact, because the process of extracting the information is also the process of making the information undeniable. Lieutenant Gerald Farrow was placed on administrative leave in February. After the internal affairs review of the complaint co-signatures in his disciplinary file was re-examined in light of the DOJ investigation and found to constitute a pattern of premature closure of meritorious complaints. The phrasing was bureaucratic, but its meaning was precise. Farrow had looked at complaints against officers in his command, complaints describing conduct that was documented and credible, and he had chosen to close them without genuine examination. He had done this not once or twice, but consistently, repeatedly, across years, in a way that indicated not oversight but policy, not error but practice. Farrow said, through his attorney, that he had followed departmental protocols in all cases. The departmental protocols were now themselves part of the DOJ investigation. Officer Torres, who had been the second car at the scene on October 6th, requested and was granted an interview with the DOJ investigation team in March. He gave a statement that described, for the first time in an official context, what he had seen when he arrived. A man in a business suit, blood on his face, against a car, officers of force with no visible predicate. He described asking Colton whether everything was under control and Colton asking him to classify the incident as a possible DUI. He described his own failure to contest that classification. He was 31 years old and had been on the force for 2 years, and his voice, according to the investigator's notes, was steady but quiet, the voice of a man speaking about something he had thought about every day since it happened. In April, a second lawsuit was filed. Robert Tanner, the man who had filed the 2019 complaint that Farrow had closed, retained his own counsel, and sued Colton and the city for the same pattern of unconstitutional conduct. Jerome Ellis filed a similar action in May. By June, the city's legal department was managing four separate but related civil cases, a federal civil rights suit, and a DOJ pattern or practice investigation, all stemming from, or interconnected with, a 47-second video of a morning on Carver Boulevard. The city's insurance actuaries ran the numbers. The city's attorneys ran the numbers. The mayor's office received a memo in early July that laid out the projected litigation exposure in the clearest possible terms. If the cases proceeded to trial and proceeded poorly, and the video evidence made proceeding poorly a high probability, the potential damages exposure across all active cases, compounded by the systemic findings of the DOJ investigation, could reach between $11 and $17 million, not including legal fees, not including the cost of the mandatory reforms that a DOJ consent decree would require, and not including the immeasurable but real political cost of having this particular narrative play out in a federal courtroom in front of a jury while the national press watched. Settlement negotiations began in August. Diana Cross sat on one side of the table. Bancroft, Himes, and Wall sat on the other. The city's negotiating team was led by a senior deputy city attorney named Hargrove who was competent and experienced and who had, in other circumstances and on other cases, given Diana Cross a serious amount of procedural difficulty. In these circumstances, with this case, with 2 videos and 4 witness statements and a disciplinary file and a DOJ investigation and 3 related lawsuits all in the evidentiary background, he was negotiating from a position that professional honesty required him to describe, in his private communications with the mayor's office, as structurally compromised. The city opened at $3 million. Diana Cross declined without counteroffering. The city came back at $4.2 million. Diana Cross produced, at the next session, a preliminary expert report on psychological harm and professional reputation damage prepared by a forensic psychologist who had reviewed Marcus Webb's case file and produced a 40-page assessment documenting the documented and measurable ways in which the October 6th incident had affected his professional functioning, his ability to engage with the judicial system without what the report described as hypervigilance-derived performance interference, his relationships with junior attorneys in his firm who were also Black and who had observed the impact on their senior partner and recalibrated their own sense of institutional safety accordingly, and the cumulative effect of that calibration on the firm's internal culture and client relationships. For $0.2 million, Diana Cross indicated, did not account for the full scope of documented harm. The city came back at $5.5 million. Diana Cross noted that the Tanner case was being consolidated with the Webb case for discovery purposes, that Ellis had retained additional expert witnesses, and that the DOJ investigation had, that same week, formally designated the Harwell Police Department as a subject entity under the Pattern or Practice statute, which meant that any settlement in the civil cases would be reviewed by federal monitors for adequacy. The city's team went quiet for 4 days. They came back at $6.7 million. The figure included compensatory damages for the civil rights violations, battery, and false arrest, additional damages for professional harm and emotional distress, informed by the forensic psychologist's report, and a structural settlement component that required the city, as a condition of settlement, to implement a series of reforms. Mandatory body cameras for all patrol officers on duty within 18 months, revision of the field stop documentation policy to require written justification. For all investigative detentions, creation of an independent civilian oversight board with subpoena power, and mandatory implicit bias and constitutional policing training for all officers with continuing annual requirements. The reforms were not suggestions. They were conditions, enforceable by the federal court that would retain jurisdiction over the settlement's implementation for a period of 4 years. Brian Colton was not named in the settlement's financial terms. The money came from the city, from public funds, from the institution that had made him possible. But Brian Colton's name was attached to a separate administrative proceeding that had been running parallel to the civil litigation. In November, 9 months after the Carver Boulevard incident, the Harwell Police Department's Internal Affairs Division, operating now under the oversight of an independent monitor appointed by the federal court, completed a formal investigation and issued its findings. The findings ran to 61 pages. They concluded that Officer Colton had conducted a racially motivated investigative stop without legal predicate, had used force that was disproportionate, unwarranted, and inconsistent with departmental policy, had submitted a false and misleading incident report, and had a documented pattern of similar conduct over a period of not less than 4 years. The investigation further concluded that supervisory failures had allowed this pattern to continue unchecked, and that the departmental policy environment, as it had existed prior to the settlement-mandated reforms, had functionally enabled the conduct at issue. The recommended disposition was termination. The Police Officers Association filed a grievance. The grievance was reviewed under the collective bargaining agreement and denied, because the collective bargaining agreement, for the first time in the department's history, was being interpreted under the active oversight of a federal monitor who had read every page of the disciplinary file and who had been specifically appointed because the city's history of internal resolution of these matters had been found by a federal court to be constitutionally inadequate. Brian Colton was terminated from the Harwell Police Department on a gray Thursday morning in November, 13 months after he had gotten out of a squad car on Carver Boulevard and walked toward a man holding a coffee cup and decided, in a fraction of a second, who that man was. He left through a side entrance. There were no cameras, because no one had known he would use the side entrance, and the press was gathered at the main entrance under an overhang, in the rain. Someone inside had tipped them, though, and 3 photographers caught him as he turned the corner toward the parking structure, a man in a gray jacket and dark pants moving quickly with his eyes forward, already past the building, already in the civilian world, already without the uniform and the badge and the institutional protection that had constituted the entire architecture of his authority. He had no other case pending against him. The city had settled. Diana Cross had made clear that any decision to pursue separate criminal referral would depend on what the DOJ investigation ultimately recommended, and the DOJ was still compiling its broader findings. The specific incident on Carver Boulevard, the grab, the slam, the false report, sat in a zone where federal civil rights criminal prosecution was possible but not certain, where the standard of beyond reasonable doubt and the requirement of proven specific intent created a narrower path than the civil standard of preponderance of evidence. Criminal charges were not filed against Colton in the period immediately following his termination. Whether they would be filed remained, as of the settlement, an open question. It was a weight that would sit above his ordinary life like weather that had not yet broken. Lieutenant Gerald Farrow was formally separated from the department on the same Thursday. His pension, after review under the collective bargaining agreement and the terms of the federal oversight framework, was reduced to reflect the years of service prior to the period of sustained supervisory failure that the investigation had documented. He did not make a statement. He did not appear at an entrance, main, or side. His separation was processed administratively, which was, in a way, entirely consistent with how he had spent 9 years of his career. The $6.7 million settlement was announced on a Wednesday afternoon at a press conference in the Harwell City Hall media room, which had low ceilings and fluorescent lighting and a modest podium behind which the mayor stood and read a prepared statement about accountability and reform and the city's commitment to equitable policing in all communities. The mayor looked slightly to the right of the cameras when she spoke, which reporters who covered her regularly noted was something she did when reading language that had been written for her by someone else, and with which she was not entirely comfortable. Marcus Webb was not at the press conference. He was in his office on the 14th floor when Diana Cross called to confirm that the judge had approved the settlement. He said, "What time did they sign?" She said, 11:42. He said, "Okay." She waited. Then she said, "How are you doing?" He looked at the city through the window. He thought about 38 years of carrying a weight that no credential could redistribute and no achievement could discharge. He thought about Robert Tanner, who had filed a complaint in 2019 and been told it did not meet the standard. He thought about Jerome Ellis and Calvin Wright. He thought about every person who had encountered Colton before the video, before the law student on the steps, before the right person was standing at the right angle with a phone in their hand, and whose accounts had been processed by a system designed to exhaust them until they stopped. He said to Diana Cross, "Is it enough?" She understood the question. Not enough money. Not enough consequence. Was justice, the shape this process had produced, sufficient to the shape of the harm? She said, honestly, no. He said, but it's something. She said, his name is on it. Pharaoh's name is on it. The department's name is on it. That doesn't dissolve. He said, no, it doesn't dissolve. He sat at his desk after the call. Through the window, the city went about its ordinary afternoon in its ordinary light. He thought about his father, who had driven a city bus for 30 years and who had pressed a silver watch in Marcus's hand on the morning of the bar exam and said nothing, because nothing needed to be said between them about what the watch represented or what the bar card would mean or what it would and would not protect against. The watch was Exhibit 14 in the original complaint. It would remain in the federal record of this case indefinitely. He picked it up from his desk, turned it over. The inscription on the back was 3 words in his father's handwriting, worn with time, but still clear: know your worth. He set it back down. Then he opened the next case file. He had work to do. The reforms held. Body cameras were deployed. The Civilian Oversight Board held its first hearing 8 months after the settlement. Use of force incidents decreased by 44% in 2 years. The numbers were not perfect, and the auditor's reports were not uncritical. But the numbers moved, and the direction was not accidental. The DOJ's pattern or practice report was 140 pages. It named the department. It named the pattern. It named the violation. It was on the DOJ website, in law school syllabi, in the footnotes of 2 subsequent federal court opinions. It was part of the record. Robert Tanner's case settled separately. He was 62 years old when he received the apology. He said he wished it had come sooner. He did not say it was too late. Kezia Okafor graduated and accepted a position at Webb & Associates. On her first day, Marcus showed her to her office and said, "Rights without enforcement are just words on paper. Your job is to make them real." She said she understood. He believed her. Brian Colton drove a delivery truck. No one where he lived knew his name. But his name was in the record, in the settlement, in the DOJ report, in the footnotes of cases not yet filed. He could not undo them. They were the shape of what he had chosen, permanent and indexed and preserved. Outside, Harwell moved. Imperfectly, resistively, the way cities move, carrying the weight of what they have been while being, in small and contested increments, nudged toward what they might become. A silver watch sat on a desk on the 14th floor. A case file was open. And justice, real justice, not the single moment on a courthouse floor, but the accumulated weight of documented truth, of names attached to records, of systems made to answer for themselves in rooms where the answers were preserved, was being built. Sentence by sentence, filing by filing, fact by painstaking fact, by a man who, when the law was used against him, used it back with both hands, and who understood that the next person standing on a sidewalk with a coffee cup and writes the institution did not intend to honor needed someone in their corner who had been exactly where they were, and who had refused, at every stage of a long and difficult road, to become smaller than the moment required. The morning of October 6th, each subsequent year, was just a morning. A city waking up, coffee shops filling, people walking to work, carrying their lives at a pace and with a dignity that was neither special nor extraordinary, but was, precisely because it was ordinary, worth everything, worth knowing, worth fighting for, worth the full, irreversible weight of the law.